compensation has to be reduced according to the portion of the negligence done by him. It is contributory negligence. Contributory negligence can be defended by the insurance company. Okay, next one. The second negligence is composite negligence. This is somewhat different negligence. The claimant or petitioner, he may not have a role. He don't have any role to play in the negligence due to the negligence of two or more other persons other than the victim. Because of their negligent act, if any accident happens, our negligent victim has no role to play in this. He is not at all at fault, but because of the fault of two or more other persons, it is composite negligence. You can read this. The injured third party was not at all negligent themselves, but can claim compensation because he is not at fault. He can claim full compensation, and the court will also award full compensation. We have insurance company has no defense on this account. If any composite negligence is there, we have no account to plead that the victim himself is negligent. We cannot take that plea because he is not at all fault. And another point, the victim has the preference to claim from any of the negligent parties. Already we have told, because of the negligent act of two or more persons, the negligence has arisen, the accident has arisen. The victim has the right to claim from any of the parties, or he can implead both of the negligent parties, and he can claim from them jointly and severally. Okay, jointly and severally. He has the right to claim from the negligent parties, all the parties together. It is his right. These are the two heads of negligence. Okay. Next, come to the point that who is a third party. All of you must be knowing that the first party is the insured. The second party is the insurer ourselves. The third party is the individual or entity. Is the individual or entity who suffers injury, loss, or damage because of an accident. Okay, he is the third party. First party is the insured, second party is the insurer, and the third party is the individual or entity who suffers injury or loss or damage because of an accident involving the insured vehicle. Okay. Here some examples, exhaustive examples are given. Third party includes the government. Government means, can you specify any government third party? Can you, any one of you explain the context under which we are compensating the government as third party? Balaji. Okay. I will tell you. For example, if the motor vehicle insured by us hits a railway track or an EB post, electric post, we are compensating the government agencies. While because we are treating that damage sustained by the government, and we are treating them as the third party, and we are compensating them. So government is also a third party. The driver, any other co-worker of a transport vehicle is also a third party as per 2019 amendment. Next one is the owner of goods or the authorized representatives carried in the vehicle. Okay, the owner of the goods or authorized representatives carried in the vehicle as per National Insurance versus Chellabhadramma and others. The judgment, based on the judgment, the owners of the goods carried therein, the authorized representative of the owner of the goods are also becoming third parties. Okay. For that only we are collecting NFPP premium, non-fare paying passenger premium. If the premium is collected, the owner of the goods, authorized representatives are also covered under as third parties. Okay. Next one is passengers of a transport vehicle up to registered carrying capacity. This point is to be noted, up to the registered carrying capacity. If overloading is there, that will be treated differently from court to court. It depends on the decision of the court. But passengers of a transport vehicle up to the registered carrying capacity can be treated as a third party. Okay. Now we have seen who is a third party, and we are to know who is not a third party, for whom we need not compensate, and we can take defense in the court. If any of these persons file application before the court, we can very well take a plea that they are not third parties. So we are to know who are not third party. Owner of the vehicle. Owner of the vehicle is the first party. He is our insured and he is not the third party. It is very important. Next one, the tortfeasor driver. That means who does the wrong, because of whom the accident happens. He is a tortfeasor driver. For his own negligence, he cannot file a claim petition. So, owner cannot become a third party. Owner of the vehicle cannot become a third party. Tortfeasor, who has committed a negligence, cannot become a third party. Next one, the passengers in a private vehicle. That we know that there are two types of policies, package policy and a liability only policy. In the context of liability only policy, please note, in the context of liability only policy, occupants carried in a private vehicle, is not a third party, where liability only policy is issued. Please note this point. In a package policy, they are treated as third parties, but in case of liability only policy, occupants carried in a private vehicle is not a third party. So also pillion riders of a motorcycle, where the motorcycle is covered only by the liability only policy, they are not third parties. If it is a package policy, they are automatically covered as third parties. Next point is gratuitous passengers in a goods vehicle. You all must be knowing gratuitous passengers means without collecting any fare or hire or something, taken for friendship or relatives or somebody, driver's relatives or driver's friends or cleaner's friends, somebody is carried along with them. It is a gratuitous passenger in a goods vehicle. They cannot be treated as a third party at all. Okay. Passengers traveling in a tractor, because tractor is not meant for carrying any passenger. So passengers traveling in a tractor is they are also not third parties. Okay. Persons, last point, persons who borrowed a vehicle. If a person borrows a vehicle with owner's knowledge, we can consider them, they have stepped into the shoes of the owner and they are not third parties. They can be treated at par with owner and they cannot be treated as a third party. These are all the points which you ought to remember while handling with the TP claim. Owner, tortfeasor driver, passengers in a private car vehicle, pillion rider of a motorcycle, both in case of liability only policy, gratuitous passengers in goods vehicle, passengers traveling in a tractor, person who borrowed a vehicle, he steps into the shoes of the owner and he cannot be treated as a third party. Now we know who are all third parties and who are all not third parties. Okay. This would help us to handle the TP claims in a better manner. Next one, very important concept of TP claims arena. This is Lok Adalats, one of the alternate dispute redressal forum. The very famous and popular prominent way to settle for out of court settlements. Generally, all the TP claims are filed before the court and the forum decides the compensation amount. But to reduce the time frame, to come to a amicable settlement, there is a way provided, that is alternate dispute redressals by mediation. Like that, we can go for this. Lok Adalats is one of the popular way of settling out of court settlement method. The advent of Legal Services Authorities Act 1987 gave rise to this Lok Adalats. Okay. You can read the contents. Article 39A of Constitution of India gave this permission. It contains various provisions for settlement of disputes to Lok Adalat. All proceedings before the Lok Adalat shall be deemed to be judicial proceeding. It is at par with civil courts. Lok Adalat courts are treated at par with civil courts, and they have been assigned a judicial status. Lok Adalats are also judicial bodies only. It is one of the very efficient and important alternate dispute redressal mechanism. The Lok Adalats shall have all the powers of a civil court. Already I told you, it has the powers of a civil court under the Code of Civil Procedure. Okay. The advantages of why companies should go for Lok Adalats, why insurers should resort to mechanism of Lok Adalats, because it is a speedy way of settlement. From the point of view of insurance company, we can easily settle it in out of court by reducing the time frame. Next one, economical to the defendants. Defendants means insurance company again. It is most economical. Why it is economical? What is the difference between court orders and Lok Adalat orders? In Lok Adalat orders, we don't allow interest. Generally, we don't allow interest as well as cost of the proceedings. Whereas it will find a place in the court orders. If court awards anything, it will be with interest from the date of filing petition till the date of settlement. That interest portion can be solidly avoided in the Lok Adalat procedures. It is very, very economical. There is a saying, even a bad negotiation is good for the company. There is a popular saying regarding the Lok Adalat, even a bad negotiator can save if we go for Lok Adalat settlements, because we are completely avoiding the interest portion and the cost as well as cost also. So it is economical. Unburdening of courts. We all know from the media, social media, newspapers that courts are burdened with so many lakhs and lakhs of cases that courts may not find time to come to a conclusion for all those such cases. If we go for resort to Lok Adalat mechanism, we will reduce the burdens of the court and all the cases will move together, and thus reducing the backlog of the cases. Okay. Moreover, we can build a better rapport with the petitioner counsel as well as the court also. The courts also will be pleased if the company goes for reasonable negotiations and settles reasonable number of cases in the Lok Adalat. We can please the court as well as the petitioner counsels also will be in a good rapport with us. Then by which we will get benefited in other contested cases also. These are the advantages of the Lok Adalat. Lok Adalat is this is the brainchild of Justice V.R. Krishnaiyer, Justice Bhagavati. These Lok Adalat is the brainchild of those justices. Next one. Okay. Coming to the main crux. The other claims, handling other claims, OD claims, fire claims, miscellaneous claims. What is the guideline for settling such claims? This is purely policy conditions, which guides us to settle the fire claims, any fire claim, MBD claim, engineering claim, or motor OD claim like that. But what is the guideline for settling the TP claims? Is it within our the conditions, policy conditions? Whether our policy conditions only will guide us to settle any TP claim? We can say no, very strong no, because most of the outside agencies are involved in deciding a third party claim. First of all, we are appointing advocates, investigators are involving. The case itself is filed before the forum. The police, we completely depend on the police records. Okay, FIR, based on FIR, based on charge sheet, based on 16013 statements, based on MBI report, we go for the TP claims. The entire settlement of TP claims depends on the not only on the policy condition, only a small portion is guided by our policy conditions, and most of the portions are decided by the outside agencies, especially based on the Motor Vehicles Act. The Motor Vehicles Act is the Bible for settling the motor TP claims. Okay. What is the purpose of enacting this Motor Vehicles Act? Licensing of drivers, conductors, registration of motor vehicles. Otherwise, there will not be any that discipline in vehicles running in the roads. Okay, control of motor vehicles through permits. Special provisions relating to state transport undertakings, traffic regulations, insurance, liability, offences, and penalties, etc. are specified in the Motor Vehicles Act. To exercise the legislative provisions of the Act, the Government of India made the Central Motor Vehicle Rules 1989, not only Motor Vehicles Act. In ancillary to that, in addition to that, Central Motor Vehicle Rules 1989 also plays a vital role in handling a motor TP claim. Okay. All these together constitute a comprehensive body of law to regulate the entire government of affairs of road transport sector and the use of the vehicles in a public place. Okay. When did first it was enacted? The MV Act was first enacted in the year 1939. Okay. First it was enacted in the year 1939. It is a social welfare beneficial. Please and try to understand the terms. Social welfare beneficial legislation to compensate the unfortunate road victims. Why we call it as a social welfare beneficial legislation? Because it is not a strict compensation as our other clients do, based on the policy condition, based on the sum insured, based on the bills and invoices, we settle the claims. It is not like that here, because non-pecuniary damages are also awarded here. It is always, the courts also take a compassionate view towards the road accident victims, in the view that they should not suffer at any point of the time. For example, even if any policy breach of policy condition or permit condition is done by the owner of the vehicle or driver of the vehicle, the court will take a liberal view towards the road accident victim, and it will order, ask the owner, insurance company to pay and recover it from the owner of the vehicle. That is pay and recover principle. The pay and recover principle is the best example which states that. So it is a social welfare beneficial legislation. Moreover, the courts award most of the non-pecuniary damages like pain and suffering. That will be decided based on, it varies from court to court according to the injury, type of the injury, nature of injury, it will be decided. The quantum may vary from court to court. So it is not a strict compensation. It is a beneficial legislation towards to have a compassionate view towards the road traffic accident victims. Okay. That MV Act is amended from time to time. Is amended in the year 1994, 2000, 2001, etc. It was completely replaced by 1939 Act was completely replaced by MV Act 1988. 1988, the Act completely replaced the Base Act 1939. After that also from time to time it is being modified. Recent major amendment happened in the year 2019 and 2022. 2019 and 2022. The Motor Vehicles Amendment Bill 2019 notified on 9/8/2019 and implemented from 1/9/19. Okay, very important. The amended bill notified on 9/8/2019 and implemented from 1/9/2019. Investigation and compensation of claims implemented from the fines, penalties, change in the compensation factor, all this happened from 1/4/2022. Okay, the bill was splitted into two, and the first portion was implemented from 1/9/2019, and the second portion came into effect from 2022. Okay. The aim of the new amendment, why there was all of a major change, major sudden improvement, what is the base for that? You can see all these are the aim of the amendment in the Motor Vehicles Act to facilitate the grant of online learning license. Previously, licenses were issued in person only, but now online facility has been introduced to replace the next point, to replace the existing provisions of insurance with the simplified provisions in order to provide expeditious help to accident victims and their families. This is the very important point as far as our companies are concerned, insurance companies are concerned. The entire compensation pattern, how the application has to be filed, when it has to be filed, all these amendments to place a major vital role in the amended Motor Vehicles Act 2019. Next point, C, to increase the time limit for renewal of driving licenses from 1 month to 1 year before and after the expiry date. This is also one of the very important change. Previously, it was 1 month grace period for renewing the license. Now it has been extended up to 1 year to increase the validity period. Transport license from 3 years to 5 years. This is also a major point to enable the licensing authority to grant license even to the differently abled persons. This is a new introduction. Then next one, to enable states to promote public transport, rural transport and last mile connectivity by relaxing any of the provisions of the Act pertaining to permits. Permit conditions are liberated. Okay, next, to increase the fines and penalties. This was introduced from the year 1/4/2022 to make this, to make a provision for protection of good Samaritans. The term good Samaritans are introduced in this amended act that we will study in detail in the next point. Okay. Okay, our this MV Act, which is the Bible for handling TP claims, it consists of 14 chapters, 217 sections, and 1 schedule. Our MV Act consists of 14 chapters, 217 sections, and 1 schedule. Okay, let it be. Why do we worry about all those things? Our third-party insurance is governed by Chapter 10 and 11. Very important. Our third-party insurance is governed by Chapter 10 and 11 from sections 145 to 166. This is our methodology on the basis of which we have to handle the motor TP claims. So, our governing body from the Motor Vehicles Act is Chapter 10 and 11 from Section 145 to Section 176. This is the methodology based on which we have to handle a TP claim. Chapter 10, liability without fault. Chapter 10, liability without fault in certain cases from sections 140 to 44 is completely removed in the Amended Act 2019, which was finding place in the earlier Act 1988. This Chapter 10 was also a guiding factor earlier. After this 2019 amendment, the Chapter 10, sections 140 to 144 completely removed from the Amended Act. This also. Section 163A, structured formula. This also is removed from the Amended Act. Okay, removed in the Amended Act, which was finding place in the earlier Act. Section 163A also removed. Chapter 10 removed. 163A also removed. Sections 145 to 176 deal with the methodology of third-party liability claim settlements by insurer. These are the sections on. There are other sections also. Apart from this, these are the direct methodology based on which we handle the third-party claims. There are other sections on driving license, permit regulations, registrations, etc., which also have a direct bearing in determining the third-party claim settlement. Apart from this section 145 to 176, some other sections also have a direct impact in determining the third-party claim settlements. That we will see later. IMT 29, legal liability to employees of the insured traveling in the employer's vehicle. Legal liability to employees of the insured traveling in the employer's own vehicle. For example, a private car owned by an employer and used to carry employees involved in accident earlier covered with 50 rupees additional premium. But now, as per IRDA circular, which came into effect from 18th October 2023, IMT 29 is an inbuilt cover in a private car policy without any additional premium. Okay, this is very important. It has become now inbuilt cover in a private car policy without any additional premium. IMT 29 is a compulsory as an inbuilt cover in motor third party liability section of a private car package policy, bundled policy, standalone policy, ensuring compulsory third party liability. Okay, now it is a compulsory section without any additional premium and it is inbuilt cover. Okay, we told now apart from section 145 to 176, there are some other sections which have a direct impact in handling our motor claims, third party claims. One of the section is section 2. Section 2 of the MV Act, which explicitly explains the categories of the vehicle. For example, motor vehicles, what is a motor vehicle, what is a motor car, what is a motor cab. Everything is described here. Okay, if you want to verify, you can verify it. It needs no explanation. Tractor, trailer, semi-trailer, everything is explained here in section 2. That alone you need to remember. If you need any clarification regarding a type of a vehicle, that definition of a vehicle, you can straight away go to section 2 of the MV Act 1988 and you can verify it. That in the Amended Act, section 2, subsection 4A, community services included. This 12A golden hour is included. Now the term invalid carriage is substituted by the term adapted vehicle in the new amendment. Okay, let us come in detail to all the sections. Section 2, definitions. Already we saw now all the type of motor vehicles are defined under Section 2 of the Motor Vehicles Act. This is a new inclusion to 4A. Whatever I have highlighted is a new in the amendment which finds a place in the amended act. Section 2, subsection 4A, community service. Instead of giving some physical punishment or some penalties, offences in form of monetary form, unpaid work which a person is required to perform as a punishment for an offence committed under this act. This is a new introduction for small petty wrongdoings. This may be used, okay, instead of going for corporal punishments or financial punishments. This unpaid work which a person has to undertake as a punishment for an offence committed under this act. This is a new introduction. Next one. This is very important section. Section 3 of MB Act is very important, which describes that no person can drive a motor vehicle without an effective valid driving license. Okay, very important section. Next one. If any OD claim is to be rejected on the basis that the driver was not holding valid driving license, you can invoke the policy condition, the driver's class of the policy condition, as well as Section 3 of the Motor Vehicles Act. You can invoke this section to repudiate any claim for non-bearance of driving license. Okay, next one. In the Section 4, the age criteria on which the license can be obtained. It is described. At the age of 16 years, license can be obtained for vehicles up to 50 cc. Next, if any person attained age of 18 years, he is eligible for all vehicle license except all non-transport vehicle licenses. If anybody attains the age of 20 years, he can apply for transport vehicle license. Okay, the age criterion is described in the Section 4 of the MV Act. Next one, 8, Section 8. This is describes regarding the grant of learner's license. Relevant to note that the provisions in the CMV Rule number 3 of 1989, CMV Rule 1989, Rule number 3, which describes the learner should be accompanied by an instructor having a valid DL in the vehicle, sitting in such a position to control the vehicle. This is first condition. Next condition is a prominent L mark. A prominent L mark in red on a white background in front and rear of the vehicle. It should be in the vehicle. L mark should be displayed on the vehicle in the front as well as rear side of the vehicle. Next, third point. A learner of the motorcycle shall not carry any other person except provided in the condition A. He should carry only an instructor who is having a valid driving license, but he cannot carry any other person. Okay, these are the conditions relevant to grant of learner's license. Okay. Next one, condition section number 9, grant of DL. It can be okay, these are all normal sections. You can go through and easily find out. Important sections only I will describe because there are so many sections. Okay. Tolye, this is a new introduction. Tolye, golden hour. The time period lasting 1 hour immediately following after a traumatic injury, during which there is a high chance of preventing death by providing prompt medical care. It is known as golden hour. 1 hour immediately after the accident. It is the golden hour, the time period in which the victim can be saved, prevented from death by providing prompt medical care. This is known as golden period. This is a new concept of the this amendment, 2019 amendment. This comes under section 12A, golden hour. Next one, there are changes in the section 14. 14, currency of the driving license. There is a major change. There are major changes. I have given it here. You can easily make it out. Transport vehicle, it is 5 years validity. Transport vehicle carrying hazardous goods, 3 years validity. Any other license below one who is below the age of 30 years, he will be given license till his age of 40 years. If a person is between 30 to 50 years, his license will be valid for 10 years. If a person is aged between 50 to 55 years, his license would be valid till 60 years. If a person is above the age of 55 years, the license is valid for 5 years. These are all the changes in the new amendment. So please be thorough with this section. Section 14 of amended MV Act. Changes are there. So please be thorough. Section 15. This is also another important section where amendment happened. As we already saw, if the driving license is renewed after a lapse of 1 year from the date of the expiry, the renewal is effective from the date of renewal only. If the renewed within 1 year, the renewal is effective from the date of expiry. Okay, instead of 1 month, previously the grace period was for 1 month. Now it is extended up to 1 year. That is the difference. You can easily remember it. And the next one, if application for renewal is made by a person who has attained the age of 40 years, the application should accompany a medical certificate as prescribed in the Act. It is also a change in the previous provisions, from the previous provisions. And the last point is, if application is made more than 1 year after the driving license has ceased to be effective, the licensing authority may even refuse to renew the license unless the applicant undergoes and passes a test of competence. Then only the license will be allowed. If he fails in the test, the licensing authority may refuse to renew his license. These are all the major provisions, major changes in the amendment. So please be thorough with 14 and section 14 and section 15 of the amended Act. Very important, because provisions were changed, altered. Okay, next one. These and all you can read and find out. As I told, I will read out the only important. I will explain only the important sections. Temporary registration certificate is valid for only 1 month and it is not renewable. Please note the point. This is valid for only 1 month, which is not renewable. Temporary registration certificate, section 43, temporary registration certificate. Temporary registration is valid for only 1 month and not renewable. Next one, certificate of fitness. Form number, it is issued in form number 38. The certificate of fitness is applicable to all transport vehicles. It is applicable to transport vehicles only. For private vehicles, it is given up to the age of 15 years. In the first registration, it is given up to the age of 15 years. Without a fitness certificate, the vehicle the vehicle registration becomes invalid. If any vehicle doesn't have valid fitness certificate, the registration becomes invalid. This is important. You ought to know the registration becomes invalid. Okay. In case of there is no fitness certificate, permit automatically suspended when a certificate of fitness is cancelled for any reason. The certificate of fitness is issued for a period of 2 years. In case of private vehicles, if 15 years term is over, it is extended for a period of 5 more years. In case of private vehicle, first term 15 years and then renewed for a period of 5 years. In case of transport vehicles, first term it is issued for a period of valid for 2 years and renewed after every 2 years. This is regarding fitness certificate. Okay. Next important section is permit. This many of the category of vehicles are coming under not necessary in the permit not necessary in the following situations. You can go through this. Easy only. If you read, you will come to know the validity of the permit. The validity of the permit is for 5 years from the date of issue or renewal thereof. The validity is for 5 years. Permit can be transferable from vehicle to vehicle of the same nature. Of the same category type of vehicle, it can be transferable. Temporary permits can be issued, even issued for minimum of 1 day or 2 days like that. But the maximum period, time limit set is 4 months. The maximum period is 4 months for a temporary need. Okay. Minimum can be anything, 1 day or 2 days or 3 days. Suppose if a vehicle leaves from Coimbatore to Kerala, tourist vehicle, it can obtain temporary permit for 2-3 days, 2 days, 3 days or something like that. Maximum period would be 4 months. Cannot be beyond that. In case of death of the owner of the vehicle, the permit is valid only for 3 months and it has to be, before that, it has to be transferred in the name of the new owner. Otherwise, it becomes invalid. Next one, section 168. No driver in a two-wheeler shall carry more than one person in addition to himself. That means only 2 persons can travel in a two-wheeler, including the driver of the vehicle. Okay. Third person is not allowed to, more than 2 is not allowed to travel. If it is, if they are traveling, it is wrong under section 128 of MV Act. Next, section 129. Sometimes they may ask this question, wearing of protective headgear. Every person other than a Sikh who is wearing a turban, driving or riding shall wear a protective headgear. It is very, very important that wearing helmet is very, very important. Protective headgear means helmet conforming standards of Bureau of Indian Standards. Shall not be of normal standard. It should meet with the standards of Bureau of Indian Standards. It comes under section 129. It is important under section 129. If it is violated, it is punishable. Next one. While a road traffic accident happens, it is the duty of the driver to take all reasonable steps to secure and provide him medical attention to the injured person, according to section 134. Now, this is a new important introduced section, protection of Good Samaritans. This term Good Samaritans was introduced in the new amended act that generally the road, we hesitate to support the road traffic accident victims. We fail to help the road traffic accident victims because of the fear that we may be taken into the custody of the police. We will be questioned by the police. We may be summoned to the court. Like that, inhibition should be there in the minds of the people, even who are ready to help the road traffic accident victims. But in order to remove that inhibitions, this section has been introduced. The Good Samaritans would be protected if they voluntarily provide help to the road traffic accident victims. A good Samaritan is protected from legal action for any injury or death of a victim that occurs due to their actions. Okay, they will be protected from the legal action. The first inhibition is removed. Voluntary assistance. This protection applies to individuals who, in good faith, voluntarily, without expectation of any reward, provide assistance at the scene of accident. The procedure for questioning such good Samaritans would be protected, will be limited. The central government can provide rules for questioning and the examination of good Samaritans, ensuring it is done in a way that it respects their convenience. Okay, it respects the convenience of the good Samaritans. Next one. Hospital obligations. Hospitals are required to display a charter in multiple languages detailing the rights of the good Samaritans. Evidence procedure. Even if they are called for any evidence, if a good Samaritan is volunteer to be a witness, it can be recorded through a video conference. Okay, in line with the Code of Criminal Procedure 1973. They will not be tortured at any point of time. This is the outcome of this new introduced section. Okay, section 134A, protection of good Samaritans. Okay, generally, we already saw who are not third parties. Some extendedly, what is our exemption from liability? Unauthorized persons in any goods vehicle, pillion rider of a two-wheeler in a liability only policy, the occupant of a private car in a liability policy, workman other than for whom premium is not collected, tortfeasor driver of the insured vehicle. Tortfeasor already we learn now who is a civil wrongdoer. He is a tortfeasor. Persons beyond the seating capacity, premium dishonored. If any check is dishonored and the premium is not collected, 64th 5B violations. This is also newly introduced drunken driving. Drunken driving of the driver who is a tortfeasor. It is also exemptions from liability. Okay, this is regarding the introduction of the TP claims. Can we move on to the next chapter? Next, okay. Now we are jumping into the main crux, the methodology based on which we are going to handle the motor TP claims. Already we have seen some important sections prior to this 145. Prior to this 145, we have seen some sections which have direct impact on handling the TP claims. Now, the methodology on which we have to handle TP claims. We are coming to the main crux of it. Important sections. Section 142, 144, which was in chapter 10 earlier, it is completely deleted. That was talking about liability without fault. This is completely deleted in the amended section. Next. Section 145. There is a slight modification in this section, which is highlighted here. Already, property included roads, bridges, culverts, causeways, trees, posts, milestones, etc. in the earlier section. Now, the amended section includes baggage of passengers. Okay, baggage of passengers and goods carried in any motor vehicle. These are also coming into the meaning of the property now. As per the amended act, these are also included in the term property as per section 145. Third party also includes the government the driver and any other co-worker on the transport vehicle. The government, the driver and the any other co-worker on a transport vehicle. They are also becoming third party as per the new amended section. Okay. This very important section, even though it is there from time to time, very, very important section as far as insurance is concerned. No person shall use except as a passenger motor vehicle in a public place unless there is in force a policy of insurance complying with the requirements of this chapter. That means compulsory insurance policy. This is mandated by section 146 of MB Act. The insurance is compulsory, section 146. In case of a vehicle meant to carry hazardous goods, that all we know, public liability policy is also required in addition to the basic insurance policy. Okay. This basic insurance policy means the vehicle may have liability only policy. Even a liability only policy will do. It doesn't specify that there should be a package policy. It should take care of the third parties on the road. If any accident happens, it has to take care of the third parties. That is the purpose of this section. And the compulsory insurance is made compulsory to protect the interest of the third parties operating on the road. Okay. Next one, basic requirements. Section 147. It specifies insurance policy is mandatory. What it should cover, what the insurance policy should cover, it finds a place in section 147. The 147 section states that it should cover any owner of the goods or authorized representative of the owner of the goods by virtue of collecting NFPP, non-fare paying passengers. They are known as non-fare paying passengers, and the premium can be collected for them. Next one, that passengers of a third party vehicle or passengers carried in a commercial vehicle. Passengers carried in a commercial vehicle that also have to be covered as a third party. Especially what is excluded in this? The gratuitous passengers. Specific exclusion of gratuitous passengers in a goods vehicle. Already we saw who is a gratuitous passenger, who is a non-fare paying passenger, or who else known to be a friend or known person to be driver or conductor or cleaner of the vehicle, who is carried for free service. Okay. Next one, named employees. That means driver, conductor, cleaner, all are removed from the WC and they are covered as a third party now. They are removed from the WC point of view and they are covered on the basic third parties. Okay. Next one, 146 is compulsory insurance, very important section. 147, who are all the persons to be covered by the insurance policy? It is described in section 147. This is another section, very, very important, very basic facts on major changes happened in this section only. Section 149. We shall see some PPT to understand this section more effectively. Okay. First of all, you should understand before this 2019-2022 amendment, how the third party claims are filed. First of all, whenever the accident happens, the police files the FIR. After that, the road accident victims file a case based on the FIR, they file a case before the claims tribunal. Motor accident claims tribunal files a case. And the case will be summoned to every interested parties, defendant parties and our petitioners, and the case will take its own course. Evidences will be there and defense will be there, written arguments will be there, written statements would be there. It will be a elaborate procedure. And after that, finally, it will be concluded by the court. Or the better thing may be the settlement through Lok Adalats. For all those, first, the claim petition has to necessarily be filed before the Motor Accident Claims Tribunal. But as per this new amendment, which came into effect from 1/4/2022, it has been mandated that no claim petition need to be filed before the court. Once the FIR is filed, based on that, the claimants can directly go to the insurance company and seek their compensation. This is a very, very major change, important change. This is a very major change. Previously, the claim petition need to be filed before the court. Otherwise, no insurance company would come into the picture. Okay. After the service of the receiving of the notice only, the insurance company will start their procedure by appointing the advocate, investigator, filing written statements, everything. But as per the new amended act, it has been, the liberty has been given to the claimant that if FIR is filed, that is enough, and the claimants have the right to claim it directly from the insurance company, even before approaching the forum, Claims Accident Tribunal forum. They can directly approach the insurance company for their compensation. Okay, just a minute. Okay. Here, you would understand from this flow chart in a better manner how the new amendment has given direction to settle a third party claim, how to award compensation to the road traffic accident victims. First one, the motor vehicle accident happens here. FIR now it is first accident report or first information report. It is in form 1. It is prepared by the IO. IO means an investigation officer, police officer who investigates the particular case. He is known as IO. The FIR or FAR form 1, it is prepared by the investigation officer from the police side. It is prepared by the IO and it is submitted to the claims tribunal. The FIR is prepared and submitted to the claims tribunal within 48 hours of the accident. Within 48 hours of the accident. At the same time, the IO submit it to State Legal Services Authority. SLSA means State Legal Services Authority. At the same time, it uploads the FIR in the State Police website, CCTNS portal. In the CCTNS portal also, state website also, the FIR is uploaded. Simultaneously, all these three things happens. FIR is prepared by the IO. It is given to the SLASA, State Legal Services Authority. It is uploaded in the police website. It is given to the victims. It is given to the victims as well as it is given to the insurance company. Okay. The FIR is circulated to all the concerned parties, SLSA, State Police website, Claims Tribunal, insurance company, as well as to the victims. Okay. It is next one, next step. Rights of the victims of a road accident in form number 2. FIR is in form number 1. Form number 2 is rights of victims. It is prepared by IO to victims within 10 days of time. They give all the details regarding the vehicle which caused the accident and necessary detail, insurance policy details, vehicle owner, driving license details. All these details would be provided by the IO to the victims within 10 days of the accident. Simultaneously, it would be circulated to all the people concerned. Next one. Next flow is preparing form number 3 and 4. Form number 4. Both are these two forms are prepared by the IO investigation officer. The form 3 is submitted by the driver. Regarding the details of the driver name, address, his Aadhaar, his driving license details, etc. are given by the driver to the IO in form number 3 within 30 days of the accident. Form number 4, it is given, it is owner's form. It is known as owner's form, which is again given by the driver to the IO within 30 days from the date of the accident, because owner is not available in the scene of the accident. The police may not have direct contact with the owner. So they will collect the details of the owner to the driver. This is form number 4. Okay. 3 is driver and form number 4 is owner. Next one. Detailed accident report. This is very, very important. You need to know about this. This is, wait. 4, 5. Interim accident report. After collecting form number 1, 2, 3, and 4, IAR, form number 5 is made ready by the IO and it is given to the claims tribunal within 50 days of the accident. From the 50 days of the accident, interim accident report in form 5. Next one. Interim accident report in form 5 is given to the claims tribunal. From there, victims form 6A and 6B. This is prepared by the IO regarding the details of the victim. Regarding the what is his name, age, occupation, address, proof for income, everything will be available in the nature of injuries, everything will be available in the victim's form, the form number 6A and 6B by the victims to the IO within 60 days. They have to get it ready and submit it to IO within 60 days. This would be provided to the insurance company also by the IO. Next flow is the detailed accident report, DAR compensation. This entire system is known by the name DAR, Detailed Accident Report, Form 7. This is very, very important. Detailed DAR is in form number 7. It is prepared by IO and submitted to the claims tribunal within 90 days from the date of accident. And this DAR will be provided to insurance company also. This DAR would be provided to claims tribunal as well as to the insurance company. Based on that DAR, the insurance company has to start its work. Based on the DAR, the insurance company would see insurance company has to submit its form 11. And this would be prepared by the insurance company to the claims tribunal within 30 days of the receipt of DAR, from the date of receipt of DAR. All other flow, that workflow, that from the date of accident, and this is only from the date of receipt of DAR. Insurance company will submit the form number 11. What are available in the form number 11? We will see it in detail because it is the form prepared by us and given to the claims tribunal. There will be 2 different situations where the first situation is the insurance company accepts its liability. Accepts its liability means it scrutinizes the entire file, documentation, vehicular records, investigation is done, and everything is fine to be fine. and the company is ready for settlement and it accepts its liability. It is one situation. In that situation, how the company would proceed? If the company is accepting its liability, and again, two different situations would occur. The first situation is it would offer an amount. If the company is ready for settlement, after thoroughly scrutinizing the documents, investigation, based on investigation, everything, it comes to the conclusion that the claim is settleable, it would offer an amount to the claimant. If the claimant also agrees for that, offer is made by the insurance company and the claimant also accepts that amount, the tribunal would pass a consent award like our Lok Adalat awards, because it is consented between the parties, insurance company and the claimants. They agree, the court will, the claims tribunal shall pass a consent award. It would pass a consent award because court will not have any objection. Since the involved parties, disputed parties are agreeing between themselves, the tribunal will just pass the consent award. Okay, this is the first straightforward situation. Next one is, here the company accepts its liability, but if there is any dispute in the amount awarded. In the first situation where we saw the amount awarded by the company was agreeable to the claimants, so it was easy for the tribunal to pass a consent award. In the second situation, the company offers an amount which is not acceptable to the claimants, In this situation, what would happen? The claims tribunal shall hear the arguments with respect to quantum alone, because no defense will be used by the company, because it has already decided that there is a liability towards that case. So it will not raise any objection or any defense from the side of the insurance company. Only the dispute here is the compensation awarded. The claimants are not acceptable to the amount awarded by the company. So in this situation, the claims tribunal will hear the arguments with respect to quantum alone and pass the award. Based on quantum, no defenses will be there. These are the two situations where company accepts its liability. One is the company accepts its liability and an offer is made. The claimant is also agreeable for that. Fine. The court will pass the consent award. The matter is over. The next situation, the company accepts its liability, offers the compensation, which is not acceptable to the claimants. In such a situation, the tribunal will hear the arguments with respect to quantum alone and it will decide the compensation and pass the award. These are the two situations. The next situation is the insurance company does not accept its liability. Where it will not accept its liability? If there is any breach of policy condition, any breach of violation, any breach of permit condition, registration conditions, the company would not readily accept its liability. In such a case, the claim tribunal shall conduct a detailed inquiry, as it is happening now. Okay, when it approaches the claimants approach the court, an elaborate trial would happen. Like that, if the company doesn't accept its liability, an elaborate inquiry would be conducted and it would be completed within 12 months. Okay, from the date of accident, 12 months from the date of accident, and the award will be passed by the claims tribunal itself, because the company is not accepting its liability. So the tribunal has come to the conclusion whether award to be passed or case to be dismissed. Based on the merits of the case, the tribunal will decide the case and it would be concluded before 12 months of the accident. These are the three situations. Okay, are you clear? This is very, very important. This is the major basic amendment as far as insurance companies are concerned. As far as insurance companies are concerned, this Form 11 would be prepared by the designated officer from the insurance company. That means who is handling the case. The court will call them as designated officers. That designated officers would fill the Form 11. And in all these three situations, in all, whether the company accepts or rejects its liability, whether the quantum is agreeable for the claimant or not, whether in all these three situations, the Form 11 has to be filled by the designated officer and it has to be submitted to the claims tribunal. In case where the company does not accept the liability, it has furnished the details why company is not accepting its liability and on what basis it is going to contest the case. That details has to find place in the Form 11. In other two cases, the company has to tell with what amount it is ready, the offer amount, what was made to the claimant, it has to be filled in the Form 11. Okay, this is very, very important. Be clear with this. In the first situation, proceedings will be completed within 6 months because everything is straightforward. The company accepts liability, offer is made, the claimants are also fine with it. So the tribunal easily passes the award within 6 months from the date of the accident. In the next situation, where the company accepts its liability, offer is also made by the company, but whereas the claimants are not agreeable for the amount, the court will, the claims tribunal hear the argument with respect to the quantum and the compensation will be decided within 9 months from the date of the accident. For deciding the quantum, the courts are allowed 9 months from the date of accident. In the last situation, where the company does not accept its liability, the entire burden will shift to the court and it will decide whether the amount is, whether the case has to be disputed, dismissed or award to be passed. It has to be decided by the court within 12 months of the accident. The entire proceedings have to be completed within 12 months of the accident. Okay. Mr. Balaji. Balaji.
Yes, ma'am.
So 10 minutes break. Shall we take, go for
Yeah,
10
yeah,
minutes?
sure.
Okay, okay. Shall we resume?
Yes, can start, madam.
Oh, okay. Okay, friends. Once again, I would tell you this is a very, very important section. That also Form 11, Insurance Form 11. 3 various situations we have discussed. Be thorough with this. And the time limits also stipulated the 6 months, 9 months, and 12 months. Please remember it. Try to remember it. Okay. These forms try to remember Form 1 to 11. Form 1, 2, 3, drivers form, owners form, DAR. DAR is another important form. DAR is form number 11. Insurance form is form number 11. These all very important forms. You please try to remember them without fail. This is coming under section 149. Okay, here we have come back to our section 149. For this explanation only, we went to that PPT slide. That it is in a detailed manner given here again. Whatever we saw there in the PPT form, it is given here. That very another point we should not miss is the aspect of pain recovery. As mentioned earlier in section 149, subsection 4 is completely deleted in the amended act. This concept of pay and recover, where the pay and recovery orders are generally given, you ought to know about that, where there is a violation of policy condition, breach of policy condition. In that case, the court inclined to award pay and recovery. That concept, that means first the insurance company has to compensate the road accident victims, and it has the right to recover it from the owner of the vehicle who is at default. The default of the owner, it has to be compensated by the insurance company first, and then it has the right to recover it from the owner of the vehicle. This is the principle of pay and recovery. This is removed from the new amended section. Apart from all this, we have seen in the PPT form, whatever happens in the section 149. This is the main important amendment in the new section as far as insurance companies are concerned. Settlement by the insurance company and the procedure, entire procedure is changed. The main basic difference which you ought to remember is previously it was every road accident victim has to approach the court to file a claim petition. Now it has been modified. Filing FIR is enough by the IO. If the IO prefers an any FIR, that is treated at par with claim petition, and the claimants can directly approach the insurance company for the compensation without filing any application before the claims tribunal. It is the major change. Next one. The statutory legal defenses available to the insurance company. Only few defenses are given to us, provided to us legally. Legally, we have only few defenses, which we will see now. The defenses is breach of any policy condition. Okay, breach of any policy condition. The next one is hire or reward. If the vehicle is used for hire or reward, or the vehicle is used for any organized racing, and the vehicle is used for any other purpose other than permitted to use. That limitation, violation of limitation as to use class. Next one is DL violation. If any unauthorized person drives the vehicle without driving license, it is a legal defense available to us. Another defense, newly war and allied perils, as it is excluded in all other claims. Here also, war and allied perils are exclusion, and two new defenses are given to us in the amended act. One is non-receipt of premium as required under section 64(5)(b) of the Insurance Act, and next one is driving under the influence of alcohol, all or drugs. These are the new defenses, legal defenses given to us. Okay, these are the only legal defenses given to us. Apart from this, whatever we observe in a particular case, specific case, we can put forth the defense. There is no harm in it. Nobody can deny our rights, but the court may not appreciate that. That is a different thing. But we have to try from our side, whatever defenses we see from our side, we can put forth it before the court. We can try to convince the court. The court may get convinced or may not get convinced. It is left to our presentation and how effectively we contest the case. It depends on that. But the legal defenses available are described in the section 150 subsection 2. This is also very important section. Only defenses available to the insurance company. All other defenses, whatever we see, negligence and all other aspects, we can take it. We can put forth before the court. There is no harm in it, but whether the court appreciates it or not depends on how we present and how the court appreciates it. Next one. The another important section is 161 hit and run. Hit and run means a vehicle hitting a person and running without leaving any details. Okay, we cannot trace the whereabouts of the vehicle which has caused the accident. It is by the English, as the English term suggests, it is hits and runs away from the scene of accident. It is hit and run. For that, there is some fixed compensation. For death cases, it is fixed as 2 lakhs, and for grievous hurt, it is 50,000. Okay. Previously, there were different sums. If I tell, you will get confused. Please don't try to confuse that. The new amounts only, please remember. For death, the compensation fixed is 2 lakhs, and for grievous hurt, it is 50,000. Previously, the term solatium fund was used to mete out the compensation for the hit and run accident victims, but the term solatium fund is removed in the amended act. A new term, motor vehicle accident fund, is introduced, which we will see in detail later. Okay, the term solatium fund is removed in the amended act. That you need to know. No more solatium fund is used in the amended act. This amount also you please try to remember, because in many years these questions are repeated. For death, the compensation amount is 2 lakhs and grievous hurt, it is 50,000. This is a new section introduced in 162. This is entirely a new section, cashless treatment during the golden hour. Already we saw what is the golden hour. It is a 1 hour immediately time period, golden hour, time period lasting 1 hour following a traumatic injury. It is a golden hour. There is new scheme is introduced to save the lives of the road accident victims. A cashless treatment scheme for cashless treatment of road accident victims during the golden hour introduced. This is a brand new amendment in the new. Now, recently, very recently, it was introduced. So it may be asked this year. The scheme name, Cashless Treatment of Road Accident Victim Scheme 2025. Even though it found a place in 1422 amendment, now only it is implemented. Notification date May 5th, 2025. Guidelines date June 4th, 2025. Treatment coverage. Those who are covered, who are eligible for this cashless treatment during golden hours, they are eligible up to 1.5 lakhs per victim. Okay, per victim. Duration for a fixed period of 7 days from the date of accident. It is applicable only up to 7 days from the date of accident. Amount is 1.5 lakhs. Period is 7 days from the date of accident. Eligibility. Who becomes eligible for this? Any person injured in an accident caused by a motor vehicle is eligible. How it is implemented? The scheme is implemented through a network of designated hospitals across the country. The scheme is implemented through a network of designated hospitals across the country. It is managed by the State Road Safety Council as the nodal agency in coordination with NHAA, National Highways Authority of India. It is managed by the State Road Safety Council as the nodal agency in coordination with the National Health Authority. National Health Authority's IT platform is used for registration, verification, and claim processing. There is an IT platform designed specifically for this that maintains all the for registration, verification, and claim processing. Okay, this is a new important section, very recent amendment, May 5th and June 4th. So you please try to remember this. Cashless treatment during golden hour. Even though it was announced in the last amendment, 1/4/2022, now only it is coming into effect. The modalities were formulated now only, and it is coming into effect now. Next one. Section 163A, structured formula compensation, which was earlier there in the 1988 Act. It is completely deleted. Okay. And it is completely deleted. Section 164. Earlier we saw section 142, 144 is completely deleted. That is chapter 10 is completely removed from the amended act. What was there in 140, section 142, 144? It was on the basis of no fault liability. 142, 144 was no fault liability. It is completely removed in the amended act. So there is a new section for no fault liability. Now, no fault liability section is 164. It is a new amendment, new change in the amended act. Then no fault liability is always fixed compensation. Okay, the compensation amounts are fixed and do not depend on the victim's income or the driver's negligence. It will not vary. The amount will not vary based on any other thing like income or negligence or any other aspect. It is totally a fixed compensation. The fixed amounts are for death it is rupees 5 lakhs. For grievous hurt it is 2.5 lakhs. Minor injuries are not compensated on no fault liability basis. Okay. Death and grievous hurt are compensated, whereas minor injuries are not compensated. It is a fixed compensation. It will not vary from case to case. No fault liability. The owner of as it is, the term itself suggests, is based on no fault liability. So, the drivers or owners' negligence need not be proved on any circumstance. It is based on the principle of no fault liability. Hence, the owners or drivers' wrongful or negligent act need not be proved. This is because it is no fault liability principle. Reduction of existing compensation. If any other compensation is already received by this no fault victim, that compensation will be reduced from this amount. This is the procedure. If compensation has already been paid under any other law for the same accident, that amount will be deducted from the compensation payable under this section. Okay. I told you, no, the term Solatium Fund previously maintained to compensate the hit and run victims. The term Solatium Fund, the Solatium Fund was maintained to compensate the hit and run victims. That Solatium Fund term is removed, and instead the motor vehicle accident fund, it is created in the place of Solatium Fund. Okay, creation of motor vehicle accident fund for providing interim relief, cashless treatment during golden hour, payment to be made in hit and run, and for providing compulsory insurance cover to all road users in territory of India. This motor vehicle accident fund will be created, and the fund will be diverted for providing interim relief for cashless treatment, golden and during golden hour, payment for hit and run accident victims, and compulsory insurance cover to all road users. Okay, where there is no insurance, that also has to be compensated. No, some fund would be diverted from this motor vehicle accident funds to that. That amount received under this section is full and final. They cannot file any other petition for wider compensation. This is a fixed compensation, and this is full and final amount. There cannot be any other petition further to this. Okay. This is on no fault liability. Very important section. 164, no fault liability. Please try to remember it. Creation, I told you, no, that all this would be interim relief for cashless payment during golden hour, hit and run victims compensation, insurance to compensate the victims, those who met with the accident out of the uninsured vehicle. All this for this motor vehicle accident fund is created. How it is created and how it is maintained. It is detailed under section 164B, establishment of motor vehicle accident fund. How it is created and how it is maintained. You can go through this in a detailed manner. Okay. Another very important section, 166. Application for compensation on fault liability basis. Section 164 was based on no fault liability. Now the section 166 is based on fault liability, in the sense that liability, that negligence need to be proved. Negligent act of the driver need to be proved. Then only application will be maintainable under this section. This is the most widely used section for filing compensation petitions. 166. It is the widest of all. One can make application under 161. That is hit and run application. One can file application under 164, which is based on no fault liability. One can file application on 166, which is the widest of all, and which is based on the principle of fault liability. This you have to differentiate. 161 for hit and run victims, 164 for no fault liability victims. Here 166, widest of all, wider compensation based on fault liability. Here, who shall make application? Very detailed, very important section. You have to know in detail. Who all can make application shall be made by who sustained injury or by the owner of the property where the death has resulted from the accident. The legal heirs of the person who died in the accident and legal representatives of the deceased. Okay, these are all the persons who are eligible to make the claim petition. Who sustained the injury or the owner of the property who sustained damages to his property or For the deceased person, the legal representatives or any authorized person can make the application. These are all the eligibles who can file the application before the claims tribunal. Okay, where they can make the claim petition. Is there any jurisdiction? Is there any limit for filing the application, or they can file it anywhere in India? No, there are some restrictions where the claim petition shall be made. It is described here, claim where the application shall be made. The claims tribunal having jurisdiction over the area in which the accident occurred. Simply speaking, where the accident occurred. The first situation is, first jurisdiction is where the accident occurred. Next one, where the claims tribunal within the local limits of whose jurisdiction the claimant resides. The second point is where the claimant resides. First point is where the accident occurred. The second point is where the claimant resides. And the third point is where the defendants reside. Defendants means insurance company, mainly the insurance company, where the insurance company is situated. On these three jurisdictions, the claim petition can be filed where the accident happens, where the claimant resides, or where the defendants reside. Who can make the application? Who sustained injury, or by the owner of the property who sustained damages to his property, or to any authorized person or legal representatives of the deceased person. These are all the persons who are eligible to make the claim petition and where the claim petition shall be made. These two we have seen. Now, as per the new amendment, I have highlighted this. This is as per the new amendment. No application shall be entertained within 6 months. Okay. Within 6 months of the occurrence of the accident, there is a time limit fixed. Previously, there was no time limit for filing the claim petition. There was no limitation, bar on limitation. Now, it has been made compulsory that the application has to be made within 6 months from the date of the occurrence of the accident. This is a new amendment, very important point to note. No, it is very important to remember. Next one. This is also important. Previously, if any, first imagine a situation. Person A, he sustained some severe injuries. He has filed his application for compensation for his injuries sustained for the accident. Okay. During the pendency of the case, he dies. He dies due to injury. He may die due to injury, or he may not die due to injury. He may have died natural death. In both the situations, previously, once the injured person dies, the legal rights are barred for claiming for his injury. If any person who has filed an application for the injuries, and if he dies during the pendency of the course, his rights are barred. Then and there, legal representatives cannot move further with the application for compensation. But as per the amended act, if the injured person dies, whether due to accident or even not due to accidental injuries, the rights with the legal representative continues. Okay, the legal representatives can still claim for the compensation of the injury of the person died. But the only one condition is that injured person should have filed that application while he was alive. If the application was not filed at the time of the injured person, the legal representatives cannot file further application, but the injured person has filed the application, and during the pendency he dies, his legal representatives can carry forward that application and they reserve their right. Okay, this is very, very important. You can In essence, if a person had a valid claim for compensation due to an injury while they were alive, the right does not vanish with their death. This is very, very important. The right does not vanish with their death, even if the death entirely unconnected to the original injury. Their legal heirs can continue or initiate the process to claim the compensation. This is very, very important. Okay. These are all the new changes. First one, 6 months limit for filing application is imposed. Next one is the injured person can, legal representatives of the deceased injured person can continue their rights to claim for the compensation of the injured person. These are the two major amendments in the section 166. But it is very, very important section. Please try to remember all the points. Who can file the claim petition, where it can be filed, when it can be filed, and regarding the injured person dying during the pendency of the case. These are the important points available in this section 166. This is the widest of all compensations based on fault liability. Okay. 169, already we told that this court, claims tribunal have all the powers of a civil court and shall be deemed to be a civil court for all purpose. In Lok Adalat also we saw this. The Lok Adalat courts have the powers of the civil court. Likewise, claims tribunals also have the powers of a civil court. Next one, very important section, 170. Section 170 petition. If the tribunal has reasons to believe that there is a collision between the person claimant and the insured. Okay, if there is a collision between the claimant and the insured, if the person against whom that our insured failed to contest these two situations. First, when there is a collision between the claimant and the insured. Second situation, when the insured failed to contest the case. In such cases, the insurance company reserves its right to contest the claim on all grounds that are available to the insured. Okay, very, very important. Insurer shall be impleaded as a party to the proceeding, and the insurer so impleaded shall have the right to contest. We have the right to contest the claim on all or any grounds that are available to the person against whom the claim has been made. Against whom claim has been made? Against our insured, the claim has been made. You should be should understand that once the driver, tortfeasor, negligent driver, who is related to our insured vehicle, if they are available in the claim petition only, if they are parties to the claim petition only, the right of the insurance company also arises. When they are not at all a party to the proceedings, insurance company also shall not be made a party to the proceedings. So it is very mandatory that the driver or the owner of the vehicle, they should be made party to the proceedings, and insurance company also steps into the shoes of the owner. So we have the right to contest the case on behalf of our insured, and we are taking all the rights which are available to him, and we are making this section 170 petition. It is a pre-requirement for filing appeal cases. In lower court only 170 petition is filed, because while filing appeal in the high court, if we are agitated by the award of the lower court, and if we intend to file appeal in the higher court, this is a pre-requirement. Without the consent of the insured, the High Court will not entertain any appeal. So, in order to protect our rights in while filing appeal, it is mandatory to file section 170 petition before the Lower court. Okay. In the lower court, we have to file this 170. Otherwise, our rights to file appeal in the higher court will be barred. Okay. This is very, very important section. 171. Award of interest where claim is allowed. Award portion. That in Lok Adalat awards, while we saw about the Lok Adalat, there was a main point, which was that interest, it is Lok Adalat awards are interest free. Whereas when the court awards, the award would carry fetch interest. In addition to amount of compensation, simple interest shall be paid and from such date not earlier than the date of making the claim. That is from the date of claim petition. The interest is payable from the date of claim petition, not from the date of accident. It is from the date of claim petition. These are the points. Simple interest from the date of claim petition. 171. By virtue of this section 171, that motor accident claim awards are interest attracts interest and from the date of accident. Okay. Next one. Section 173, which talks about appeals. Okay. Lower court passes award if either of the parties, whether ourselves or the claimants, either of the parties are not satisfied with the award of the lower court, award of the tribunal, there is a legal asylum for us. We can very well prefer appeal in the next forum. Appeal can be preferred in the next forum. For small, if any calculation error is there, we can file a revision petition in the lower court itself within 30 days. For any clerical error only, review petition, revision petition is allowed. If any technical error is found, if we see any defense we have taken, which is not appreciated by the court, if we feel it is to be challenged, we can prefer appeal in the next forum. Not in the same court will not revise that and will not hear the or argue the same thing. So it has to be appealed before the next forum. Any person aggrieved by the award of a claims tribunal may within 90 days. This time limit is very, very important. 90 days from the date of the receipt of award. From the date of receipt of the award, prefer an appeal to the High Court. 90 days is very important. Such award, if 90 days time limit is exceeded, we have to file delay condemnation petition. That will take very time and the court, sometimes the High Court may not incline to allow our petition if it is filed delayedly. So it is very, very important. Those who are in the TP department, please make note that we should file appeals in time. Then only it will be allowed, and if once filed in time, we can easily get the stay orders also. So please be specific. Such award shall be entertained by the HCC unless 25,000 rupees for filing appeal. A minimum fees is required. That is 50% of the award amount or 25,000, whichever is less. For filing appeal, it is mandatory to deposit 25,000 rupees or 50% of the awarded amount. Next one, it is a new amendment. No appeal shall lie against any award of a claims tribunal if the amount in dispute is less than 1 lakh rupees. That means more than 1 lakh rupee awards only shall be appealed against. This is a new provision as per the Act, amended Act. Okay, appeals very, very important. And time limit 90 days from the date of the receipt of the award. We have to deposit either 50% of the award or 25,000, whichever is less. No appeal shall lie against any award of rupees 1 lakh, less than 1 lakh. These are the three important points which is coming under section 173, which is very important. Okay, last section, very important, another section, recovery of money. Generally, for any policy breach, the courts inclined to award pay and recovery order. How to recover? There is a lengthy procedure. If you file execution petition, that is a very lengthy procedure. We have to produce the details of the property of the insured against whom we are making that execution petition. That and all will not be available to us even if we try through our investigators, somebody like that. So it is a better simple procedure to file an application under section revenue recovery. It is revenue recovery, which is initiated through the district collector. Okay. Section 174 allows us application shall be made to the tribunal, who will in turn issue a certificate for the amount to the collector. The tribunal will directly order it to the collector and collector will start the recovery. Okay, it will be a better, somewhat easier procedure, because if we file execution petitions directly, court will not admit our application without the property details against whom we are filing the execution. So it may not get allowed. Even if it is get allowed, it is a lengthy procedure. This one is a better, simpler procedure for in pay and recovery cases. Okay, these are all the very important sections, which are the methodology on which we have to deal the entire TP claim. Section 145 to section 176. All the important sections I have discussed here. Okay. Here, I have given some offenses committed and the penalty under which section it is to be that they are to be punished. If section 3 is regarding driving license, mandatory driving license. If anybody violates that section, it is punishable section 181. Like this, these are all given. For permit, 66 permit is necessary. If one violates 192A, he is punishable under section 192A. For insurance is compulsory, no, we will come to that. Insurance is compulsory. 146, insurance is compulsory. If anybody violates that, he is punishable under section 196. Drunken driving is punishable under section 204. Like this, that section which mandates the thing and punishable under which section. I have given a list. It is not an exhaustive list, but whatever available I have given. If any violation is not placed here in the above list, it will be punished under section 177 for minor penalties. Whoever contravenes any provisions of this act or any rule, regulation or notification thereunder, if no penalty is provided for, the offence shall be punishable for the first offence with one fine under section 177. Okay, wherever there is no relevant section for punishment, it will be punished under section 177. It is the meaning. Okay. Okay, these are all regarding our important sections. Is there any doubt? We will move to now BNS. This is a new introduction before in 2023, Bharatiya Nyaya Sanhita. BNS, it is known as BNS 2023. Bharatiya Nyaya Sanhita is India's new official criminal code, which replaces Indian Penal Code 1860. It came into effect from 1st July 2024. Okay. That MV Act, which IPC we used earlier, the relevant section I have given here. Earlier IPC 279, rash and negligent driving. It is 281 BNS 2023. Deals with the offense for rash and negligent driving. Okay. Rash and negligent driving, it is in section 281 BS 2023. Earlier 337 IPC, simple injuries, new section 125 subsection A, BNS 2023. Okay. Next one, grievous simple injury. 337 means simple injury. Next one, 338 IPC 1860. The new relevant section is 125B BNS 2023. This section states that anyone who causes grievous hurt to any other person by acting rashly or negligently. This is regarding grievous hurt. This is the point. 125 subsection B BNS 2023. Okay. Next one is 304A. 304A deals with causing death by rash and negligent driving. The new section in BNS is 106 BNS 2023. 302 IPC, which is murder. The new section is 101 IPC BNS 2023. Why I am mentioning murder here is, in some cases, FIR will be filed under 302. In that case, we have to be alert and we have to take defense that it is not road traffic accident and it is murder. For such cases only, I have given here the murder reference also, 101 BNS 2023. Another section is 339. Those who deal with the OD claims, theft. For theft, it is the new section is 303 BNS 2023. Okay, this is regarding new BNS. Okay, now we will discuss some of the important landmark judgments, which are all the trend-setting judgments. These are all the trendsetters. Even though they came some years before, still they persist and they are being referred by the tribunals everywhere. And that landmark judgments we are going to discuss now. Srimati Sarla Verma and others versus Delhi Transport Corporation and another. The date of judgment is April 15, 2009. The claim petition was filed by the claimants for seeking increase in compensation. The court held that out of this, the outcome of this case, claimants in case of death for claim compensation must establish. The court directed the claimants as well as the insurance company. For the instructions given to the claimants were, in case of death, the age of the deceased must be proved with some valid document. The age of the deceased must be proved. There should be some proof for income of the deceased. Simply they cannot say he was earning 15,000 per month, 12,000 per month, something like that. There should be a valid proof for the income of the deceased. Next one, the number of dependents. It also should be produced. We can get it verified through the legal hire certificate. Okay, the legal hires we can collect the legal hire certificate and we can cross verify and check them. In this, the major outcome of this case was to have a uniformity in determining the compensations in case of death. This is a death case and the SC director, there should be a SC means Supreme Court. Supreme Court director, there should be uniformity and consistency in determining the compensation in death cases. Step 1, how it allotted some steps, how to ascertain the correct compensation. It directed some 3 steps. Step 1, ascertaining the multiplicand, this term, multiplicand. This means the income of the deceased per annum should be determined. out of the said income, a deduction should be made in regard to the amount which the deceased would have spent on himself. Do you understand? If one person would have been alive, he should have spent some amount on his own for buying his dress, for his entertainment, for his food, for his stay, for his comfort. He would have spent something. So, a portion should be reduced from the income of the deceased, which he should have spent on himself by way of personal and living expenses. The balance only has to be taken as a loss of income because he should have been alive, he should have spent on himself. So the balance only can be taken, the loss of income towards the family members. That is known as multiplicand. The amount which we are deducting, it is known as the 1/3, 2/3, something like that, 50%. There is a table for that. That is known as multiplicand. The Sarala Verma judgment decided there should be a standardization of multiplicand. Okay, next one. This is multiplier. Based on the age of the deceased, that multiplier should be chosen. The multiplier should be chosen from the table. There is a table for multiplier also based on the age of the victims. Starting from the age 18 till above 60, there is a table which I have shown you, which I have included here, which you will see later. Based on the table, that multiplier should be chosen. Next one, actual calculation. The annual contribution to the family when the multiplied by such multiplier gives the loss of dependency to the family. These are all the 3 steps given by the Sarala Verma case. They directed the claimants to produce the apt proof for the age of the deceased, proof for the income of the deceased, and the number of dependents. And the 3 steps are also given for ascertaining, calculating the exact loss of income. Here, the main important aspect is it introduced future prospects. Previously, when a deceased was earning rupees 10,000, only that 10,000 was taken for entire calculation of the compensation. Even if he was in the age of 30 or 40 or 50 or 60, only that 10,000 income, current income was taken for calculation of loss of dependency. But Sarala Verma case included the aspect of future prospects in case of organized workers, organized or employees working in organized sectors. This future prospect concept was introduced by the Sarala Verma case, but only for the employees working in the organized sector. Next one, standardizing the multiplicand scale. We saw what is multiplicand, that was standardized. Standardizing the multiplier scale. Even now, the Sarala Verma's multiplier table is adapted. Even after the landmark Pranay Sethi judgment, the Sarala Verma's table of multiplier is even now adapted, and it was confirmed by the Pranay Sethi judgment. Next, another, the table is given here. Next important judgment, very landmark. This is again a Bible for TP Claims Tribunal. National Insurance Company Limited versus Pranay Sethi judgment, which is pronounced in the on 31st October 2017. Changes in the components of computing special damages or pecuniary losses. 2 types of losses are awarded in claims tribunal, awarded by claims tribunal. One is special damages or pecuniary losses or financial losses. For example, loss of income, like that. If any other thing, loss of injury, that pain and suffering, loss of life, something like that. If any non-pecuniary losses, general damages, which are known as general damages, they are also awarded. Special damages are pecuniary losses. Another set, general damages are non-pecuniary losses. Both are awarded by the courts in the compensation. They are all the components in the compensation. Again, Sarala that Pranay Sethi tried to standardize the multiplier. It decided previously, before this Pranay Sethi judgment, some courts were taking the mother. If the deceased is a bachelor, the courts were taking the age of the mother, the age of the parents together, the average age of the parents, something like that. Some courts were adopting some methods and some other courts were adopting some other method. Different methods were adopted by the courts. But Pranay Sethi judgment guided the deceased is age of the deceased is the basis for applying suitable multiplier. Okay, that parents' age and all that were removed, and the age of the deceased is the basis for applying suitable multiplier. Okay. In death cases where application has been made under 166, the multiplier as indicated. I told you, no, even Sarala, that Pranay Sethi case confirmed the Sarala Varma's table of multiplier. Here you see from age band 15 to 20, 21 to 25, 18 is the multiplier. The age band and the relevant multiplier are given here. The minimum, you may try to remember, for the age, minimum multiplier is 5 and the maximum 18. Also standardize the future prospects. In the Sarala Varma case, we discussed this, that the future prospects was introduced in the Sarala Varma case only, but only for the employees who were working with in the organized sector. But the Pranay Sethi judgment extended it to non-salaried people also. The concept of future prospect was extended to non-salaried people also. This is the change in the Pranay Sethi judgment. I'm keeping this one. Here, see this. Standardizing formula for awarding future income should be applied to self-employed persons also. Whereas Sarala Verma case introduced it and allowed it only for the people those who are working in organized sectors. But the Pranay Sethi judgment extended it to persons employed, self-employed also, non-salaried people also. The self-employed people and persons with fixed salary were also allowed future prospects as below. That salary, permanent job, the table is given here. Okay. If a person is below the age of 40 and he is in a permanent job, his future prospects addition will be for 50%. For example, if somebody is earning 10,000 in a government sector and his future prospects will be considered as 5,000, that is 50% extra of the 10,000, and his total salary would be considered as 15,000. This is how this works out, the table. This table is for self-employed person and this is for permanent salaried person. This is slightly higher than these people. Those who are self-employed, their future prospect is slightly lower than the people, those who are in the permanent job. Next, that multiplicand, which we saw in the Sarala Varma case, deduction towards personal expenses are also standardized by this judgment. It gave a table for a bachelor, only parents. For married person, how many dependents are there? It is like this. It is standardizing the personal expenses also. Revision in compensation under conventional heads in case of death. General damages or non-pecuniary losses. It were standardized. Under any death compensation, only these components shall take place. As per Pranay Sethi judgment, there should be loss of estate, there should be loss of consortium, there should be funeral expenses. Okay. In addition to the loss of dependency, loss of income. These are all the only three heads which should be allowed in death cases. This was standardized by the Pranay Sethi judgment. Loss of estate, it is a fixed compensation. For loss of estate, 15,000. Loss of consortium, 40,000. Funeral expenses, it is 15,000. To enhance with increment of 10% in a span of every 3 years. Every 3 years, it will get 10% extra towards this head. But this is a fixed compensation. Only 3 non-pecuniary losses can be allowed in death cases in addition to the loss of income. Loss of income will be there based on the income of the deceased, multiplicand and multiplier, it will be decided. Apart from that, only these three heads will be there. Loss of estate, loss of consortium and funeral expenses, those two with a fixed compensation. There will be an increment of 10% every 3 years. The concept of loss of consortium, the consortium is especially for the spouse. Those who has lost his spouse, companion, it is awarded, it was awarded. But after that, some judgment altered that consortium concept also. Consortium means the right to consortium would include company care, help, comfort, guidance, solace, and affection of the deceased, which is lost to the family. With respect to a spouse, it would include sexual relations with the deceased. Modified concept of consortium. Parental consortium is also awarded nowadays. Earlier, only spousal consortium was awarded by Pranay Sethi. It was confirmed by Pranay Sethi. But now, modified form of consortium is also awarded. Parental consortium is granted to the child upon the premature death of a parent. If any child loses his parent due to road traffic accident, that child will be allowed parental consortium. Okay. The amount will be the same. Consortium amount will be the same, but the persons are extended. The purview of the consortium was extended. That only spouse was eligible for consortium before this judgment. After this, the parents also, child also getting the parental consortium. The parents are also getting the consortium for the death of their child. That is filial consortium. Filial consortium is right of the parents to compensation in case of an accidental death of a child. Okay, the child dies in an accident, their parents are eligible for filial consortium. Earlier, only spousal consortium was there. Now, parental consortium and filial consortiums are also extended. Compensation under head of loss of consortium awarded by Pranay Sethi was reviewed by judgment. Magma General Insurance versus Nanuram 2018. Okay, this judgment only altered the concept of consortium. Okay. The amounts are as fixed by Pranay Sethi judgment, which you please note. The amount is only 40,000. But it is extended to more number of beneficiaries. That's all. Okay. This all regarding the important judgments. Pranay Sethi, very, very important landmark trend setting judgment, which you are to know. Next one, important judgment. Mugundevangan versus Oriental Insurance Company. It was pronounced on 3rd July 2017. And it's very simple. The LMV license holders can drive a vehicle, transport vehicle, which is below 7,500 kgs. This is the crux of this judgment. Okay. Conclusion. The effect of transport vehicle is related. You can read this. A driver who is holding license to drive a motor vehicle, he can drive transport vehicle of such class without any endorsement to that effect. Okay, up to 7,500 kgs. If any transport vehicle is there, a driver holding a light motor vehicle license can drive the vehicle without any endorsement. That is the main. This is also another very landmark judgment, trend-setting judgment. Mugun Devangan versus Oriental Insurance. Okay, Mugun Devangan versus Oriental. Now, recent judgment. K. Nagendra versus New India Assurance, which was pronounced in October 2025. The SC is repeatedly reaffirming pay and recover principle. Even if the vehicle owner has committed a technical breach of the insurance policy, the company must first pay the full compensation to the third party victim or their family, and they can recover it from the owner. This is the Nagendra pay and recovery principle affirmed in Nagendra versus New India Assurance, October 2025. Next one. Bridge Bihari Gupta versus Manmath and others. The legal liability for motor accident remains with the registered owner of the vehicle. That is, in case of name transfer cases, when the registered owner is different and the policy owner is different. In such cases, the legal liability for the motor accident remains with the registered owner. Okay, this is the crux of the judgment. The insurance company cannot escape its liability to indemnify the registered owner merely because the vehicle's possession was informally transferred to another party through an agreement. This protects victims who might otherwise be denied compensation due to technicalities of an uncompleted sale. Okay, the company cannot escape liability in such cases, and the registered owner is liable to pay compensation. Bajaj Alliance versus Ramba Devi, which was pronounced in 2024. It reaffirmed the judgment of Mugun Devangan, where the transport license endorsement is not necessary to drive a LME transport vehicle. Okay. The case which involves Bajaj Alliance Insurance affirmed that LMV license is sufficient and does not require a separate transport vehicle endorsement for such vehicles, upholding the previous Mugun Devangan judgment. These are all the very recent judgments. Okay. For your easy reference, I have given this limitations. Filing MCOP claim petition, filing written statement, all these I have given you in a table already, which we have discussed. This one regarding the section 149, this form from who has to prepare this form and to whom it is to be submitted, and the time limit also I have specified for FAR, which we have seen in section 149. Form 2, Form 3, everything I have described here in a tabular form. It is easy for your remembrance and learning. For that, I have prepared this table. This Pranay Chethi table also I have given you for your ready reference. Pranay Chethi table. Okay. This multiplier band reduction towards personal expenses future prospects, general and non-pecuniary damages, everything I have given here. Okay, for your easy learning and reference. Okay, any doubts? I think we have covered all the portions.
Can
Ma'am,
unmute and
from
ask.
exam point of view. Hello.
Yes, tell me, sir.
Yeah, ma'am, from exam point of view, if it is nothing is mentioned that how to calculate, then we should use this Pranay Sethi, correct?
Yes. Pranay
Yeah,
Sethi only is the latest judgment on which the calculation has to be made.
Okay, but if specifically it is mentioned Sarla Varma, then we should not use that last two calculations.
Sarla Varma table is confirmed by the Pranay Sethi. That multiplier table you can use. Pranay Sethi is also using the Sarla Varma table only.
Okay.
For
No, the
multiplier.
last two things are there, na? This deduction for the personal use and the future prospect. That also
That
should
is
be
given
taken.
in Pranay Sethi table. Last table I shown to you now, where I have mentioned the multiplicand, multiplier, future prospects, everything is available. That table you please refer, sir. I show you once again.
No. My question is not that, ma'am. My question is in exam, if they specifically mention Sarla Varma, in that case, we should not or we can use this future prospect.
No. Nobody will tell like that because that judgment is overruled by the Pranay Sethi judgment. So nobody would ask you to calculate any compensation based on Sarla Varma judgment. It cannot be a question.
Last year there was a question
What
based
was
on
the question?
Yeah, it was mentioned that please do the calculation based on Sarla Varma.
Sarla Varma. Yes.
Is it? Can you please share me the question?
Madam, exam question we can't share. It was there in the exam.
It was there in exam.
If you tell me the question, I would provide you the correct answer. But Sarla Varma judgment is overruled by Pranay Sethi judgment. So why they are asking?
That practical aspect is fine, ma'am. Just for exam point of view, we are confused whether we should use or not.
For that, multiplier is same only. For both of these, multiplier is same only. In the point of view of that future prospects, only for the organized employees, employees who are working in the organized sectors, future prospects need to be calculated. For other non-salaried people, you need not take that into consideration. Okay. That is the difference. That is the difference. Multiplier table is the same.
Hello. Ma'am,
Hello,
regarding
yes,
the pay and recovery, if any question is there on pay and recovery, is it we should say that it is still holds good or not? Because in the recent judgment, they are upholding.
This is disputable still now. That is pending before the larger bench of Supreme Court, and it is yet to decide. Till now, it is confirming the upholding the judgment, previous judgments, and the pay and recover principle continues to be there till now. The final decision has not been done by the Supreme Court. Principally, theoretically speaking, we can tell that in the amended act, it is deleted. Where the accident happened before 1422, it holds good pay and recovery principle.
Ma'am, there's a change for every 3 years for the consortium and everything. Na? So now that
yes, madam.
Should we now include 10% loading now?
Yes, 17. It was the judgment was in the year 2017. 17 plus 3, 2 slabs can be included. We are in the third slab.
Now in the exam, should we now put 3 slabs and then only give, ma'am?
Yes, exactly.
Hello.
Yes, sir.
Ma'am, in TP policy, if we give unnamed PA cover,
If they are covered under third party or only PA is covered, ma'am?
Pardon?
In TP policy, if we give unnamed PA cover
Okay.
to occupants,
Ah.
only PA amount is covered, or they are come under unlimited liability?
PA means only PA will cover, sir. If they are
Not,
covered under package policy, they are treated as third party and they are eligible for a wider compensation. If it is a liability only policy, they are not treated as third parties and they are eligible only for PA compensation.
If we give unnamed PA only also?
Yes, yes.
Right. Thank you.
Ma'am, can you please explain that section 170 once more?
170.
That in pleading insurer in certain cases.
Yes, madam. That means if there is some collusion between the insurer and insured and the claimant, they collude, they are hand in glove, and the insured is not appearing before the court. It is a situation. Another situation, naturally, none of the insured will appear before the court and they will not defend their cases. Only insurance companies defend on their behalf. In both the situations where the insured is not appearing before the court, the insurance company reserves the right to take all the available defenses available to the insured. The insurance company step into the shoes of the insured and they can file this 170 petition seeking, reserving their rights to take all the defenses available to the insured. This is a pre-requirement for filing appeal because we the insured, the appeal cannot be filed. That's why this provision is given. This is a pre-requirement. It should be filed if any company decides to go on appeal on quantum basis. It is an important document. Is it clear now, madam?
Okay, fine.
Okay.
Thank you, ma'am.
Okay.
Ma'am, for 170, if there is even if there is no FC also, we can go for appeal.
Yes, madam, we can defend the case. If you are
Oh.
not satisfied, your that defense are not considered by the court, you may prefer appeal based on the situation. Okay, you can for every appeal, it should be you should be ready with 170 application.
Okay, ma'am. One more thing, for loss of consortium, 10% increases, that is from date of accident or how will?
On which date the award is pronounced? 10% slab.
I didn't get. 10%
Madam?
slab is from?
Actually, the judgment is pronounced in 2017.
70. Okay, ma'am.
Judgment. From that date, it has to be increased. 2017 to 21 slab, first slab. 20 to 23, next slab. We are in the third slab now. Like that, it increases.
Okay.
Madam,
even cases also it will applicable, madam.
One by one, sir. One by one.
Yeah,
Madam, for Pranay Sethi.
One important thing. Regarding section 170, if we are disputing insurance itself, there is no policy, then 170 cannot be filed. Okay?
Yes, we should not.
That is the point.
If
yes.
we file the 170 petition, we are accepting the insurer relation. In case where there is no policy, it is better to avoid filing 170, but it shall be filed in some other form. For exam point of view, you need not know all those things, but it is better to not to file 170 in case where there is no insurer relation is there. It can be filed in a modified form.
Madam, can you illustrate with an example for Pranay Sethi how the calculation is to be done, ma'am?
Yes, ma'am. That I will calculate and give it to you, madam. That will be better.
No, just the formula. Just the formula is enough, ma'am.
Formula means income. Okay. First, you take the income minus tax. Less tax. Always it is less tax. Plus add for future prospects. As per the table. Plus future prospects minus Into 12. Into 12 means 12 months. Into 12 into that multiplier. Into multiplier divided minus multiplicand divided by 365. This is the formula. Okay, madam?
Okay, ma'am.
Better I would do a calculation and give it to you. Okay?
Yeah. Okay,
Yes,
ma'am.
madam,
Thank you.
please.
Okay,
Madam.
I will do it. I will do it.
Please
Okay.
share in
Madam.
the group calculation.
Yes, madam. Sure. I will share
Madam,
it in the group.
including this, madam,
Ma'am,
including
one
this
question,
10%
please.
increase.
Yes,
One
madam. Tell
question.
me.
Ma'am, there is
Yes.
in section, there is when there is dispute in amount in 1 lakh. So after that we can appeal. It is the amount difference or it is the amount 1 lakh?
No. It is the award amount, not the difference. It is the award amount, madam. Awarded
Madam,
by the
award
court.
amount or amount in dispute?
Not
Yes.
award in dispute. If the amount awarded by the court is less than 1 lakh, appeal is not preferable. You are barred from preferring appeal. The award amount is more than 1 lakh only. You have the right to prefer appeal. Not dispute. How can you decide? It is the dispute amount. It may be different for you and it may be different from the court of view. So dispute amount is not the deciding criteria. It is the award amount.
Madam.
Yes, sir.
In bundled policy, is pillion rider cover or not, madam? First year.
But it is also in dispute only. Actually, we can take a defense that it is there is a recent judgment. They are excluded from the third party purview.
Whether we have to take it not covered from first year only, no, ma'am?
Yes. Because both policies are considered as separate policies. So we can take the defense that they are not treated as third parties.
Yes, ma'am. Thank you.
Yeah. Yes.
Ma'am, these days mentioned for Form 3, Form 4, these 30 days are
Yes,
from the date of.
Some are mainly all are from the date of accident. Whatever forms the IO prefers, it is from the date of accident. Finally, whatever the insurance company has to submit after the DAR, it counts from the date on which the DAR is received by the insurance company. From that, it is 30 days. All others are from.
Ma'am, this 10% increase is on the 70,000, right? The total is 70,000. So it is every year 7,000 is added, or on 77,000, then again interest of 10% on the.
No. No, madam. It is not like compound interest. It is on the base amount only. It is not compound interest.
Every year 7,000 is getting added.
Yes. From the base amount only.
Okay.
So as on date, any calculation is to be done, then it has to be every year. Like if some compensation is being awarded in 25, so from 17 onwards, we have to take it up to 8 years. So
yes, sir. We are in the third slab.
Okay.
So now it will be plus 14,000.
1421. Completion of years 14,000 only. 14,000 only. If the 26th onwards, third slab also will be completed and that will be 21,000.
Okay. Thank you, ma'am. So it will be 84,000, right?
Yes.
Thank you.
Yes, ma'am.
Ma'am, generally this TP claims this award to be calculated from the date of accident or from the date of award, ma'am?
No. Date of claim petition, not from the date of accident, not from the award. It is from the date of claim petition filed, date of registration of the claim petition.
Okay, ma'am. Thank you.
No. As per the new provision, no application need to be made before the court. Directly he can approach the insurance company. So under the circumstances, which date should be taken?
Pardon, sir?
No, under the circumstances, which date shall be considered?
Sir, based on DAR, the DAR will be provided by the IO to the company. And we can arrange our own investigation as usual and we should try to collect all the documents pertaining to the victim and his details, his age proof, his income proof, his salary, everything. We have to collect through our investigation agency, and DAR also will support us. The driver's details, owner's details, everything will be provided by the DAR. Based on DAR and our investigation, we can come to a conclusion.
No, suppose if we are offering an amount and it is not acceptable to the claimant, then he approaches the court. So under the circumstances, which date shall be taken for payment of interest, if at all allowed?
From which date it is filed before the court?
Okay.
Yes.
Ma'am, as per the new provision, the in goods carrying vehicle, the owner of the goods or representative can be treated as third party.
Yes, madam. For that only we are collecting NFPP premium. But one thing, one condition, they should travel in the cabin. They should not travel on the body of the vehicle along with the goods. They should carry in the body cabin of the vehicle. Okay.
Okay.
They can be treated as third parties.
For Act only policy, for a private car, for occupants, is there any provision where they can be covered as third parties?
No, they cannot be treated as cover parties, sir. But recently,
no, they cannot be. But is there any provision or any judgment where some status is accorded to them as third party?
No, actually, they are not third parties.
Yeah. They are not third parties, but is there any judgment or any provision where they can they can be considered as a third party, or any judgment or something is there?
No, not like that. No court has violated that, but there is a recent Supreme Court direction that we include them also. There should not be any variation between the package policy and the Act policy. Tungala Dhanalakshmi, you can read that judgment. That is not decided by the larger bench of the Supreme Court. Tungala Dhanalakshmi versus National Insurance Company. That is still going on. That is not yet decided. In that, Supreme Court is directing the companies to consider package policy as well as liability policy at par. That is not yet decided. No court is allowing that.
So until that decision is taken, we have to by normal whatever the current provisions going on.
Yes, it will hold good. It will be upheld. Oh.
Ma'am, what about the minimum retention for third party property damage?
6,000.
Ma'am, someone was saying that it has been removed. Nowadays we are doing policy in the policies also. It cannot be come due to minimum.
No, madam. I think it's not removed.
Okay.
Anyhow, let me confirm. Okay.
Yes, ma'am.
Yes, ma'am. Smita,
what about kids traveling? Ma'am?
Actually, kids traveling below the age of 12 years, they will be treated as a child. If they exceed the age of 12 years, they will be treated as an adult as per MV Act.
In two-wheelers also, ma'am?
In two-wheelers also. But practically speaking, the courts will take a view that if parents go, that children cannot be left alone. So they also will be carried, no. In that, in such cases, if along with the parents, the children also go, the courts will take liberal view only.
Okay.
In that case, what is the multiplier, ma'am, for less than 15 years?
Less than 15 years, it is 5. Multiplier is 5. Starting from 15, it is 18.
So any child
is 5 or 0,
say
5. There cannot be any multiplier like 0. Minimum for a multiplier is 5 only, sir. For children below the age of 15 is 5.
In the same sense, if it is more than 70 also, we have to take 5?
Yes, sir. Yes, sir. 5. Some courts are taking 3 on their own, but it is not established principle.
Okay.
But how the courts are awarding the compensation in that case?
Pardon, sir? I don't get
No,
your question.
no, see, now you said that it is after 15 years, the multiplier is 5. So there are so many incidences of deaths are taking place. So how the courts are going that way? If a child is, say, for example, 8 years old,
there is a fixed compensation for them. Generally, they would be awarded some 5.5 lakhs, 6 lakhs. Some judgments are there that notional income will be fixed. Based on that, multiplier 5 will be adapted and compensation would be allowed, which will be around 6.5 lakhs, 8 lakhs, something like that. Notional income would be considered, sir.
See, okay, this case holds good in case we presume that a child up to 14 years is not required to undertake any job. Suppose if a child is between the 14 to 15, in that case, what multiplier will be? Is it be 5?
Up to 15, it would be 5 only, sir.
Oh.
Yes, sir.
Ma'am, in hit and run cases, how they decide the insurance company?
For insurance company, the whereabouts of the vehicle cannot be found. So that compensation is met out from a fund specifically made for that. The insurance company, the vehicle details itself is not known to anybody. So insurance company cannot be decided. There will be a nominated insurance company for settling the hit and run cases from time to time, as decided by the government. It will be decided by the government. A company will be, for example, United India for some period. I think now it is United India only settling agency for hit and run cases. Application has to be made to the collector and he will order the commissioner to conduct inquiry. Finally, the award will be passed and United India will meet out from that fund created specifically for hit and run victims. That is how it works out.
Okay.
Madam, regarding this pay and recovery, right? Earlier
Yes,
it was
sir.
under section 149(4).
Ah.
So after revision, it comes under 174, right, madam?
Sir, 174 revenue recovery. It is actually revenue recovery, but the principle is deleted. That principle is theoretically deleted, but the courts are still ordering pay and recover. Because there is a larger bench hearing going on in the Supreme Court before the Supreme Court, but in the last judgment, it affirmed the pay and recover order.
So if a question comes for under which section this pay and recovery comes, we have to go for
now it is
149(4)
deleted,
itself,
sir.
right?
Now it is deleted. In the new amended act, it is deleted. It is removing the principle of pay and recovery.
Okay, fine.
Yes, sir. Yes, sir.
No, his question was in case if such a question is given, then which section to be mentioned?
It is previously 149 subsection 4.
Oh.
Ma'am, for third party property damage, can they approach without going to court or how?
For government agencies, madam, we can directly settle them across the table. For example, EB post, railway post, something like that, we can directly compensate them. If in case of private property damage, for example, a house wall is hit by our vehicle, something like that, they have to file the petition before the court, and then only we can settle the amount. Directly, we cannot entertain such applications of private parties.
Private parties. Okay, ma'am.
Now in the
they also come have under interim relief now, ma'am. That is deleted now. Ma'am, earlier we used to have interim relief now, ma'am. That is deleted now.
Yes, interim relief and are not there. 140 that was interim relief was there. 140 section is removed. Now no fault liability. That 164. That was interim relief and it can be extended by 166 application. Now that concept is removed. Only no fault liability application is there. It is the final application and it cannot be further extended by any other application.
Ma'am, this third party property damage, can it be reimbursed, ma'am?
For government agencies, we can reimburse it to insured. On production of original estimate, original bills, original receipts, we can reimburse. For government agencies alone, EB post, railway post, etc. For all other private properties.
Hitting the EB pole, they bring a letter with the sign of the TNEB authority that so-and-so has paid this much for. That letter is enough, ma'am?
No, that is not enough. That original estimate should be there on the date of accident. Okay. After that, that original receipt, they will discharge a receipt that the property is repaired fully and we have received so-and-so amount towards vehicle number should be there, date of accident should be there. Everything has to be verified. After that, you can make the payment to our insured.
Okay.
Against proper acknowledgement. Yes.
Ma'am, for third-party property damage, private people, they also go to MCOP or some other court?
Yes, MCOP only. MCOP only will be filed.
Okay.
Yes, sir.
Where the amount is exceeding in case of TPPD damages. Say, for example, if someone comes with a claim of, say, 20 lakhs. Because the damage is huge. Say he has
the difference,
a transformer.
Sir. We can quote the policy conditions and we can take the difference.
No, whether any such instances where the pay and recover is there over and above our limits?
No, it is not like that. No pay and recovery is there. Yes.
So only they can award up to the extent of
yes, sir. We can
cover, whatever.
No. The court will decide, sir. The court will decide, but we can strictly take the difference. Finally, left up to the forum. I have not seen any pay and recover in such cases.
Hello, ma'am. As per the new provisions, the claimant needed to file a petition. So in those cases, how the section will be triggered, like it's a no fault liability or will be but 166, how that section will be triggered in those cases? Petition is filed with the some section. No?
Yes, sir.
So if the how the section will be triggered when the claimant is not filing petition to the court and the police authorities directly sending the details to the court, how the section will come into the picture?
Sir, actually, when they approach directly, you can decide, insurance company can decide whether it falls under no fault liability or fault liability. Based on that, you can decide. If that offer fails, that offer made by the insurance company files, they will file a petition mentioning the relevant section. If negligence is proved, yes, in that case, they will file with the relevant section. Court will accept based on some section only, with relevant section only. Otherwise, court will not allow any petition.
Thank you, ma'am.
Ma'am, in the form 2, where the inquiry officer is giving the details to the claimant, will they not specify all this information to them regarding the section and all?
Section and all, it is the duty of the lawyer. He will file the petition under the relevant section.
So then what will be communicated in the form 2, ma'am?
Form 2. No, if the negotiation fails, only the case goes to the court, no? While filing before...
Will the police authorities mention any section?
Where, sir?
The police authorities which are sending details to the court, will they mention any section?
No. It is not their duty to mention any section on which the application to be filed. It is the claimant's advocate. He will file under the relevant section. If it comes to the insurance company directly, they will file.
Okay, ma'am.
Sir, okay, sir. I think we are out of time. Okay.
I have only one doubt, ma'am. Hello.
Yes, sir. Tell me.
Can you please explain the difference between fitness for fitness and permit for commercial vehicles for the new commercial vehicle, that is transport vehicles, and while renewal? Can you please explain the validity, ma'am?
Sir, actually, the fitness is valid for through 2 years. The validity of the fitness certificate is for 2 years. The permit validity is for 5 years. It can be renewed every 5 years. Fitness certificate can be renewed every 2 years. Okay.
Okay. Then renewals will be for 2 years or 1 year, ma'am?
2 years. 2 years only. 2 years only. For the 2 years.
While renewal
permits
also they will be giving
only
for
are
2
for
years.
5 years. Permits are for 5 years. Okay. Practical questions. I will send you a calculation sheet, sir. It will be shared in the group by the organizer.
Okay.
Okay. Thank you all. Thank you.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Ma'am.